perspective of the medical development. So we have to awaken the patients also, and the community and the society also, that if we restrain the doctors to take immediate decisions in the emergency, then there may be loss of life and limb. Because in certain cases, they may have to deviate from the settled school of medicine or the surgery or other things, because through their best skill to which he is there, it is necessary to operate in that manner. The judges, the patient and the other persons of the society are not experienced persons to see whether the doctor has gone according to the norms as a surgeon, as a medical practitioner, or as a nurse, or otherwise as a hospital. When we come to the negligence, and we want to say that negligence in medical field, we have to say whether the hospital is performing the duties in a hygienical way, is the OT is stable, is all sterilized instruments are there, or the proper care has been taken or not. These are the things which can maybe judged otherwise being a disputed fact. But when the question of applying the technicalities of medicine or operation or other medical science comes, then the judges sitting either in the criminal courts or in the civil courts or in the consumer courts at all the levels are not specialized in medical science. So therefore, when the judgments are given on medical science, they have to be very cautious in it. And in that eventuality, the help is sought by way of expert opinion by the medical practitioner. Because the medical practitioners, by their expert opinion, help the judge to reach to a right conclusion. They give the material, that this is the material on which I have reached to the conclusion that there is medical science or not. If that medical board or medical expert to whom the things have been sent for opinion has not given the true opinion, then the fault lies in the person concerned, that he is not dealing with the honesty, with truthfulness, with loyalty. Then those special circumstances, medical counsel is there. Of course, medical counsel is not so effective to give relief to the patient, but at least it can take action against the erring doctor, even to the extent that the registration can be cancelled. Now, suppose a doctor says he is not possessing any degree or in medicine or that. He has depicted the same. He is not professed of that possession which he is professing. And he undergoes that treatment of a patient. And ultimately it is proved like that even if, and it comes into wrong. To my mind, even if the medical counsel says, no, it is in accordance with that medical science, but that person is not possessing that medical qualification. An homeopathic person starts giving the allopathic medicines to the patient. And some injuries come. The thing is going on better, no harm, no complaint, nothing like that, and he is doing the practice and going on. But once the harm is passed, then the question of medical negligence comes. And then it is to be seen whether he was doing performing his duty, whether there is any breach, whether that breach has come into any harm and injury to the person. So before deciding any criminal case or civil case or a case before the Consumer Protection Act, these things are to be necessarily seen. Consumer Protection Act was introduced in the year 1986 to give summary relief to the person concerned, and then limited to the patient concerned. And to come before the Consumer Protection Act, it is must that the person must be consumed, means that some consideration has been paid. Under the Consumer Protection Act, every services are covered to give protection to the consumer. And similarly, medical protection is also covered. But services which are rendered free of cost are not covered. And when the doctor is giving services under the contract of service, then he is not covered under the Consumer Protection Act. He may be liable for negligence under the Criminal Act or the civil cases or the tort, but he cannot seek protection under the Consumer Protection Act because to come before the Consumer Protection Act, one has to be a consumer and the services should be as per the defined under the Act. Now, not only this, Consumer Protection Act has taken a very care of it that the frivolous complaints should not be filed. Because if we say everybody is rushing to the court for every injury, whether it is contributed to him, sometimes to say in a layman language, in fact we try, all of us, try to be a doctor first. We treat ourselves first. Self-doctoring is very prevalent to my mind in India. Or we will ask a friend, I'm suffering from nose, this thing, what should I take? So first of all, I am a doctor to myself. So now some awakening is to be also made in the patients also, that please consult your doctor who is duly qualified. Don't go to the quacks and magic mongers and get them treated from there. So if they do like this and then something has happened, so now the medicine has, patients are being treated through stem cells. Of course, the doctor, it is the duty of the doctor to tell the patient that I am treating you like this. This may be the side effect of the dose. If you feel like this, please tell me. It may be drowsy. It may give you some vomiting effects. This is the duty of the doctor. And if he shuts from that duty and something else, then again a matter of to be filed. The Consumer Protection Act says that if frivolous complaints are filed there, then even the patient or the person who is coming for protection to the consumer court will also be fined. Not only this, if a person has been fined in the order and he is not complying with the order, then under section 27, penalty is not for the person, doctor, but for the complainant also. That order can be executed against the complainant also. So all these stringent things are already there. But what is lacking is this, that we are not using the laws as intended by the parliament and made after good efforts, and our Supreme Court has elaborately laid down so many principles in various judgments. And the latest judgment by the Supreme Court is dated on 17 February 2009. That is Dr. Martin D'Souza versus Muhammad Ishaq. So in that judgment, so elaborately the Supreme Court has Justice Kartik Markey has very nicely, elaborately, is that with rather than circumstances also, he has given a list of so many cases, starting from the Bamskis and before that, he is there with all the cases. And then he has said that it is must now, before issuing notice to the doctor, that the expert opinion must be taken and the doctors should not be hired. So I say that awakening is necessary to make the laws known to the public in its right perspective and not in an ignorant perspective that just any wrong, rush to the court. With this thing,
so everybody has spoken very well on the topic. The main purpose of the topic is that we should get the proper medical benefits and facilities. The medical negligence should not involve the cases, but rather people should get the benefit of that. So anybody is having any question on that, please?
Thank you, sir. Distinguished speakers and friends. As we all know, medical negligence as such in the Consumer Protection Act is based on the liability factor. That's number one. As one of our friends, the speakers has very clearly read out also, none other than the Honorable Supreme Court has laid down that even judges are not eminently suited to go into matters of medical parlance or the extent or degree of examination. It is good for us as jurists or as lawyers treating handling matters or dealing with matters of legal heirs of deceased patients to speak in these terms. So by inference, As one of our distinguished speakers, who is also an honorable member of a consumer forum, has pointed out, the members should invariably, all those who are not doctors are excluded, are not suited to sit in the forum in judgment on such medical negligence matters. They are reduced to pen pushing clerks or those who speak out manuals. That's number one. The second thing which I would request our speakers to point out is, what about medical negligence in case of Indian nationals who go abroad? When I was in London handling a client's matter, there was an Indian student who came to Ireland, he got treated and he died due to medical negligence. Our Consumer Protection Act, nor even the normal procedural laws, provide for any direct remedy either here or in Ireland. So what do? What is the remedy? This is the level which we have to think about medical negligence and its remedies, and not necessarily confine ourselves to what has been done, what has been said, what is being handled. I would request them to also express their views on how to deal with medical negligence on that plane of the field of law, please. Thank you.
Yeah. I would just like to answer for your second question, because I'm an expert in that, plus I have already gone to many countries in the world. So the question is that how to get the medical benefits or something like that in abroad, when you go abroad.
Under the prevailing provisions of
I tell you. Whenever you go abroad, you have to go take the insurance from the insurance companies, maybe Oriental, maybe ICA, whatever it is. So these insurance companies cover you up in certain countries. These are the group of countries: USA and London. USA and London. That is a separate group. And other countries, Asian countries, Southeast Asian countries, that is a separate group. They charge you separately for both the countries. So there is also a kind of thing that one, you have to pay $100 or $500 for how much amount you want to get it done. So for $50,000, there is a separate amount according to the age group. Similarly, there is for $2,50,000 and $500, there is a separate group. So whenever you go to USA, London or any other countries, and you carry in something like that, you have to inform the insurance agencies as well as the medical hospitals over there, which are covered by this, because separate agencies cover the separate hospitals. You cannot get a treatment from every hospital over there. So you inform both the agencies. They take the recommendations from the agency. They charge you $100 if you are have put for the $100 for $50,000. You have to pay $100 from your pocket or $500 as per your amount which you have paid as a premium. Then they will take it to the hospitals. Then the hospitals take care of you up to that amount only. But the charges are very high, and some persons, because of those charges, don't get the insurance. So they have to pay from their own pocket. I know one case. The person fell down over there in USA, in California. Just I was there last month. He fell down over there, but he did not have the insurance. He went to the hospital with his son. The son's policy never covered the policy of his mother or father or brother, whatever it is. So he had to pay from his own pocket around about $50,000. Next time he went, he said that I will not take the insurance company from there, but I will take from India. He was paid after that because he was not covered from that country. So you have to get the things insurance companies over there. If you die over there, then the insurance company from which you have got the insurance from India, because they have got a tie-up, because as Bajaj has got with Alliance, similarly Tata has got with AIG, American Insurance Group, so they have got a tie-up. So they get the money from over there, and that company takes care of you over there, and while in India they take it. But there is a particular time, from 90 days, 120 days. If one day is over and here you are not covered. And while you are traveling in the airlines, so airlines take care of you. If you don't have any insurance, airlines will definitely take care of you up to 5 lakhs or as for your economic class and business class ticket. So you have to take the insurance. That is my experience plus my suggestion whenever you go abroad. To have to take the insurance from here, because the companies over there, they don't cheat you. If you got the insurance, you will definitely take it. Because here it happens that you will, because of, if you don't have recommendations from doctors or insurance companies, you can have to pay from your own pocket and go consumer code or something like that. But in USA, London and foreign companies, they never cheat you. If you got the insurance with a tie-up, you will get the treatment properly and you